welcome everyone this afternoon. It's December 9th, and I point out that date because I just want everyone to know that we're very much on the cutting edge today, and we have a real privilege of having Garth Jacobson here with me. Just as a reminder, I'm David Tingstad. I head up the business and real estate group at Beresford Booth. But we're always working hard to stay on top of all the latest changes in the law, and today we're going to talk about a big one. For many years, I've had the privilege of being a part of the American Bar Association's LLC Partnership and Unincorporated Entity Committee. It has been such a blessing to me, and Garth Jacobson has actually been the chair of that committee in the past. He has accomplishments too many to name, but I'll name a few of them in addition to being our former chair of the ABA Le Pew Committee, as I still like to call it. He's been a member of the Business Law Section Council, which is a bunch of really smart people high up in the American Bar Association, trying to keep the business law section abreast and make sure that Congress knows of the ABA's position on a lot of issues affecting business lawyers. He was a gatekeeper of our committee task force dealing with the Department of Treasury on these very subjects, and has for many years. In addition, he's retired now as a senior government relations attorney and compliance officer for CT Corp and a whole bunch more things. Garth, we could probably take our whole time talking about all the things you've accomplished, but welcome. Really pleased that you would take the time to join us to talk about the Corporate Transparency Act. And maybe what I ought to do is just kind of throw it out to you just for a minute to introduce the act, maybe give a little background on how in the world it came to be. And I know there's been a lot of twists and turns over the years, but what are we faced with? What is it? And then we can maybe get into a little bit more. I mean, there's a ton here, but I know just yesterday that the Financial Crimes Enforcement Network, affectionately known as FinCEN, came out with just a few hundred pages of rules trying to implement the thing. But I don't want to get into that. But I guess I'd like to turn it over to you and let you talk about what in the world the Corporate Transparency Act is.
Well, thanks, David. It's interesting. I've been messing around with this for probably about 15 years or more. And so about 15 years ago plus, Senator Levin tried to get a piece of legislation passed that happened to have Senator Obama's name on it as a sponsor, which basically was the Corporate Transparency Act. And in essence, it requires the disclosure of the beneficial owners of business entities. Now that act never got passed 15, 20 years ago, but it kept rattling around in Congress until this last year. And the Corporate Transparency Act was adopted into the National Defense Authorization Act, which mandates the creation of a national database for beneficial ownership of many businesses. And it requires an affirmative election by those companies exempt. So basically what happened was, this whole idea of this database of all the beneficial owners has been, enacted. And, to kind of give you some texture on that, what it is the idea that law enforcement believes that they can't get the information about companies through the normal process. So they want to know the beneficial owners and whoever controls the entity. Law enforcement, and I could go on to a long spiel about the differences between what law enforcement thinks and what the business community think. But the point is that they got this legislation passed, and I could give you a long history of different legislation in various states that in tandem with this. But the reality is that we are now facing a situation where all businesses, and we'll talk about the carve-outs, but all businesses are going to have to file with FinCEN a report that basically discloses the information about their company. And it will be, there. Well, it's a real game changer, and it's something that law enforcement wants, and the business community, I think, is still trying to figure out what to do. Now, one thing that I will give you a little more context, and that is that this all ties in with the Bank Secrecy Act and what the banks have had to do over the last 2 decades or so as it is built up. And so the banks have to have know their customer requirements. And so the banks felt that that was so onerous that they turned around and they said, well, wait a second, we want help in this area. So then they supported this legislation that requires basically all small businesses to provide this information to the feds, and then the banks will have that information. But perhaps we can get back onto the script that David put together. That's a little bit of the background on this. But
well,
David,
you use some magic words here, Garth, and maybe this is a good time to talk about that. So first of all, without getting into the database that FinCEN will create, for a business owner, let's just take maybe somebody who owns a few apartment complexes, or someone who has a store and has 15 employees or so. So let's just kind of maybe think about it at that level. What does that business owner, what does this now require that business owner to do in terms of telling FinCEN? What you used a beneficial owner. What is a beneficial owner, and what do they have to do?
Okay, well, let me back up just a skosh and talk about what we're talking about here. In essence, the target of this legislation is all businesses that have less than 20 full-time employees, make less than 5 million in revenue, and they also have to have a presence in location in this country. So in essence, what we're talking about are small businesses. Pretty much everyone else is exempted out. So this is what they're going to have to do. They're going to have to file a report with FinCEN that names the beneficial owners, and that's anyone that has 25% or more economic interest in the business entity, whether it be an LLC, a corporation, or one of the alphabet entities that we all know about and sometimes go to, LLPs, et cetera, basically any entity that's formed by filing with the Secretary of State's office. Anyway, what the beneficial ownership is someone that holds a 25% or more greater economic interest. Now, the problem is, and we have debated this thing to death in the LLC committee about the problems with that sort of analysis, because we know that many businesses have interests that might be springing, they might be contingent, they might be 25%, yeah, maybe, but here are the exceptions and so on. And so I'm not going to answer those questions because they're going to have to be sorted out by very smart people. Now, the other thing that you have to provide is the name of the person in control. And again, we all know that many companies have like a triad of people that all have to agree on something, usually family businesses, the sisters, or the sister and brother, or the parents, or the father and the son, or whatever. And when you say, well, who's in control, they point their finger at the other person. So
that's right.
Therein lies one of the major problems that are going to have to be resolved. And I'm hesitant to say that the proposed rules that were just published yesterday really don't answer that question very well. Yeah. for some, but for a lot, it's going to be not an easy question to answer. But that's the concept. The 4 people, assume you have 25% interest, would be the economic interest and then the person in control. And I might add too that if the person in control is an employee, then they're not considered the person in control. So then you get into these other issues of, is that person an employee, or are they actually, someone else? And so
what in addition to just identifying the name of the individual, the human, if you will, the control person, is there any other information that has to be provided, or you just say, nope, Garth Jacobson's in control of that entity, or is there more about Garth that we have to tell FinCEN?
Oh, but wait, there's more.
Yeah, exactly.
You have to provide, their name, address, and their government ID information, and a photo of, or an image of it too, which is basically kind of a, show us everything you know about that person.
Right.
And what I might add too, and that is to give you a little more context on how this is all going to work, for all entities that are formed after, or I should say filed, although the language is just downright goofy, but so any entity that you have filed with the Secretary of State's office after these rules take effect, they will have to make this filing within 14 days after the Secretary of State notifies them, or after the Secretary of State files their documents, incorporation or the organization documents. So that's one of the triggers. And then within 1 year after the effective date of these rules, all other entities are going to have to submit a filing making this disclosure to the feds. So you better be up to speed and ready to go when these rules take effect. Now, the notice period will end, I believe, February 7th. And so when the rules pop up after the comment period ends, I don't know, but it could occur anytime thereafter. So you better be ready, I guess is what I'm saying.
Yeah, no, absolutely. There's a lot to be ready for, and so with the reporting to FinCEN, then what do we know, if anything, about the confidentiality of that information, about who might have access to it and when? Do we know anything about that?
Well, that question kind of divides into 2 different categories. One category is who's going to have access to this information, and basically it's law enforcement will have access to it, and it's a very low threshold for them to obtain the information. They just have to have kind of a reason for asking for it, which is not the same thing as subpoenas and other items which the court has a regular threshold. And there really aren't any Fourth Amendment protections that exist in this category. Now, the other group that will definitely have access to it upon waiver, which would be the financial institutions. So in essence, you form a business entity, this report gets filed, and then you go to your bank and the bank says, okay, I want this information. And so then you grant the bank a waiver to go into the database that the feds have, and they will then use that as part of their client due diligence process.
Yeah. So what do you think? I know it's too early to tell, but you've been thinking about this for a very long time. Any thoughts about how a small business owner who is about to form their business, or maybe already has, what they ought to do to be preparing for this, these reporting requirements? What, if anything, should they be doing?
Well, here's the problem that is going to happen, and that is that there is an obligation of the reporting company to submit this information. But as we know, there will be people who are the beneficial owners. In other words, take an LLC where you got, say you got 4 members, and those 4 members, one of them just hates the government and simply says, hell no, I'm not going to give you my government ID, and you all can go to wherever. And so you're going to have to somehow have the ability to obtain this information. Maybe it's in the organizational agreement that says that when you come on board as a member with 25 or more % interest, you have to provide this information to the LLC, to the manager of the LLC. So those are the type of things that you should be thinking about when you do your drafting agreement of the organizational agreement for an LLC.
So is it the company that has the reporting obligation, or the individual owners who have the reporting obligation, or both?
Well, it's the company, but then therein lies kind of the challenge, and that is who is going to be making that report. Mm-hmm. And the way the language reads now, it's possible that an attorney who is the formation agent could be on the hook for providing this information if they're the ones that effectuate the filing. So therein is another issue that I think attorneys need to start thinking about, and that is that you want to make sure that you are not the one that is responsible for making the submission of this report, unless you have all the information from your clients and you know that that information is going to be, accurate, and that they're not playing games with you. That kind of begs the question, what do attorneys need to do? And that is that you need to consider your engagement letters and making sure that your clients know that you may have to make disclosures that might violate Rule 1.6 of the Model Rules of Professional Responsibility. And there may be other things that you need to be concerned about too. But you need to protect yourself, meaning the attorneys need to protect themselves from these sort of things. Now, I might add one other question that you kind of alluded to before, which is the privacy of this information. And there is a penalty that exists. I got to make sure my computer, there we go. For some reason, my battery wasn't plugged in, so sorry about that. Right. Anyway, just technical glitch there. We're fixed right now. Anyway, there is a penalty for unauthorized disclosure of this information, and you need to make sure that you're not on the hook, because that penalty is like $250,000 and 5 years in prison. I don't think it would apply to attorneys, but I don't know about that.
Yeah. Well, so certainly for those of us who form entities, for those of us who represent entities, and then the entities themselves, certainly need to be taking precautions given the stiff penalties that are involved here for violation. And just right now, there's a whole bunch of uncertainty. Do the state, I'm thinking specifically about secretaries of states and registered agents. I realize this, and I'm about to ask a question, Garth, that's not on the script. So
well, that's okay.
So forgive me in advance here. So, do secretaries of state or the registered agents, are they implicated in this act at all, or is this primarily for just the entities and lawyers?
Well, the secretaries of state, there's 2 things that they're going to have to do. One is to, basically, they're going to be called upon to provide information to all the people that file documents with them. And that will be some sort of notice to them that they have to get this federal filing done also. So you can expect something from the Secretary of State that will be part of the evidence that you receive when you file that, or you get back after you submitted your filing. The other thing that is going to happen is that the feds will have, they will probably do database scraping. In other words, they will eventually have the entire database of all the secretaries of state's offices, business records, which means that then they can cross-reference all that and figure out compliance.
Right.
I wouldn't worry about that immediately, but it will be something that will occur, and that's what the Secretary of States are going to have to do. Now, the Secretaries of State, I'm sure what's going to happen is they're going to be slammed by people asking questions because it's just guaranteed that they are going to be the people at the switchboard trying to explain, and I don't know what they're going to do.
Yeah.
I feel sorry for them. I'm glad I'm not working there.
That's right. What about as your beneficial owners change for a company? How often do you have to update the information, or is that one of those things we don't know yet?
Well, according to the proposed rules, it would be 30 days after there's any change. So in essence, if you change your address, if you change, if you get a new beneficial owner, someone comes into the LLC or exits or whatever, that information all has to be updated within 30 days of the event. Now, the good news is that there will not be a requirement for annual reports, at least at this time. So for all of us that have had clients that never get their annual reports in and then come to you saying, oh my God, I forgot to do that 5 years ago.
Right.
You don't have to worry about the annual report, but what you do have to worry about is making sure your clients are sensitive that anytime there's a change, they need to submit the filing. And so they have 30 days in which to do that.
Yeah.
There is one good thing that I saw in there that is kind of nice. Well, I shouldn't say nice, but according to the proposed rules, if someone dies, then you don't have to get that filing completed until after the probate is wrapped up. So, that could be like 5 years later.
Yeah,
But
yeah, absolutely.
well, I don't know. I shouldn't say 5 years later, but we all know probates take a while. Right. So at least the death of a member will not trigger that 30-day requirement upon their death. It'll be 30 days after the probate's completed.
So I guess we have a decent handle to the extent we can at this crazy stage and where we are on beneficial owner, and while we certainly don't have maybe clear definition of who that is, particularly in the LLC context, but we have a general idea of what that is, and we know these are small businesses that we're primarily talking about. So you mentioned some revenue targets, some employee targets. So if I have say 25 employees, but only, dare I say, 3 million of income, which I guess I better be thinking about my business model. But in other words, if I'm not both, am I exempt, or is this an either or? If I have more than 5 million, I don't have to report. Or if I have 5, or do I have to have 5 million and have the number of employees, or how does that work?
Yes, you're going to have 5 million in revenue and 20 employees, full-time employees.
Yeah.
The jury's still out, or at least I'm not certain about the question about what if you have seasonal employees, like you hire, 500 people to run your ice cream stands throughout the area, and then the minute the rain starts falling, you shut those things down and you only have 3 people. I can't answer that question at this point. Yeah. But the point is that you have to have 20 employees, 5 million in revenue, and you have to have some permanent location. Now, one other thing that we didn't talk about, and I think is important, is who else is exempt. And basically, it's a very long laundry list of entities that are generally regulated, banks and securities operations. One that I find a little bit interesting is that public accountants somehow got themselves on that list. Yeah,
I was looking for lawyers to be added to the list too, Garth, but I didn't see.
Well, we tried, and we're going to still try because lawyers are regulated. Yeah. But there's a long laundry list of things, including nonprofit organizations. So my guess is we're all going to start filing nonprofit organizations, even if they're making money, Yeah. But that is that's a huge loophole. Now, it also applies for foreign entities, meaning foreign outside the country. And there's a huge loophole there that I thought was very interesting, and that is that they have to be registered with the Secretary of State. Now, if you're a foreign company doing business in Washington and you don't register with the Secretary of State, then technically you don't have to file this report. And which I might suggest is a loophole, because the penalty for not filing, not registering to do business in a state, means that you don't have the authority to initiate a lawsuit against somebody. But if you don't anticipate any litigation in your operations, why bother? I'm not making that suggestion, but I'm just saying that might be one of those loopholes that someone's going to have to look at.
Well, so now we just got a few minutes left, and I want to be very respectful of your time, Garth. But I maybe get your crystal ball out, and what do the next, I don't know, 12 to 24 months look like in your mind about when we think the reporting obligation is going to start, and what and how much chaos this is going to create for everyone.
Well, the reporting obligation is going to start when the rules become effective. That's in the statute, and that will, that'll all kick in. We have to find out when FinCEN comes up with this incredible database that they're going to have. Right. Because if their database is not in place and operational, then they're going to have chaos. But that's their problem, not ours. But what we have to do is we have to anticipate that when this happens, you will need to start making these filings. We, meaning the business entities, will have to start making the filings, and we attorneys better be ready to advise our clients what they need to do. And the existing entities, and you're going to have to go back through all your files and say, we help so-and-so incorporate or whatever. Those existing entities are going to have to file within a year. And so this is probably something where you might want to send out a letter to all your clients, and maybe even former clients, saying, hey, by the way, folks, this is coming. Right. If you want to chat with us, we will chat with you, and maybe update your organizational documents too.
Yeah. Absolutely. Well, this is certainly an emerging area. When we scheduled this webinar, we didn't know these rules were going to come out. We're still waiting for them. So at least those have come out. But as you say, it's only a couple hundred pages. So oh, goodness gracious, it's a whole lot of new stuff, and there's a lot more to come. And so Garth, I really appreciate you hopping on here and sharing some of your wisdom. I'll give you the last maybe 30 to 60 seconds. Anything else you want to share with us about the act and what we can expect?
Well, I guess the one thing I would remind you, and that is the penalty for not filing these reports is $10,000 and possibly 2 years in jail. Yeah. So, if that doesn't get your attention, I don't know what will. I mean, we represent many clients who a $10,000 hit would be very painful.
That's right.
So I think it's something that you can't ignore. It's not like missing an annual report, where your annual report, the penalty is you might lose your name, but right. Which is important. But so all I'm saying is that get on top of it as early as possible. We will be doing seminars with our committee, the LLC committee will be doing seminars on this that will dive deeper in this. There will be ethics concerns about this too that you need to be apprised of. And basically, don't blame me because I'm the messenger. I followed this for 15 years and often tried to stop it, but what can I say?
Yeah, it's what we're left with. So yeah, a lot more to come on this. We're just kind of learning as we go, and there will be a ton of additional information. So Garth, thank you very much. My suspicion is that I may burden you another time to come back and chat with us again, as we know a little bit more sometime here in the future, in another year or two. But definitely I'll be paying attention to this, and there's a lot to protect ourselves from. So I really appreciate your time and your insight. So thank you very much.
Thanks, David. And there will be seminars. I will provide you the information on that.
Great.
Some will be for CLE credit, others not, but there's a lot of people that can help you, and we want to be there to help you.
Yeah, well, it sounds like we're all going to need a lot of help. So thanks very much.
Thank you so much.
Yeah, on to further retirement, right, Garth?
Well, if this is retirement, I guess I'm
retirement.
Thanks
All
so
right.
much.
Thanks, Garth.
Bye.